Hey, it's audiovisual proof. Let's get started quickly. This is the defendant's cover page to the defendant's reply in support of their motion to dismiss for failure to state a claim, which is a total of 7 pages in length, but I'm only going to show the table of contents to the defendant's document because it tells me all I need to know in all of its glorious absurdity and ridiculousness. The defendants and counsel for the defendants are attempting to persuade the assigned judge, J.P. Stadtmueller, that I have conceded without any actual proof when I have proven breach of contract and defamation of character with the substantial amount of digital evidence to corroborate my claims. The table of contents reads, Plaintiff does not dispute that the CDA and the First Amendment bar his claims against the defendants. Absolutely false. Plaintiff concedes that he cannot allege breach of contract. Absolutely false. Plaintiff concedes that his defamation claim fails as a matter of law. Absolutely false. Plaintiff concedes that he did not allege any other claims. Absolutely false. This document is extremely laughable because nowhere in any documents filed during the course of this legal matter do I concede and admit defeat, yet counsel for the defendant's statements appear to come off as facts based on no factual evidence that I made these alleged claims of concession. It is as if the defendants are anticipating the assigned judge will ignore my reply brief and memorandums in opposition to the defendant's motion to dismiss and are literally dictating to the assigned judge statements allegedly made by me. This document appears to show the level of desperation the defendants and counsel for the defendants are willing to stoop against a pro se plaintiff rather than themselves admit defeat against a pro se plaintiff. Here is a copy of my plaintiff's reply and memorandum parts A and B. Feel free to pause and read, and you tell me if there are any concession statements within my opposition reply brief. I already know the answer, and the answer is no. Due to the defendant's astonishing absurdity with their latest filing, I quickly addressed the document with a brief reply which reads as follows. Now, after I, pro se plaintiff in this legal matter, submitted to the clerk of court on December 13, 2021 at approximately 10:22 a.m. a reply brief in opposition to the defendant's motion to dismiss for failure to state a claim upon which relief can be granted, which ultimately defeated the defendant's motion, it appears the defendants and counsel for the defendants are attempting to engage in a back and forth charade with the defendants and counsel for the defendants' personal and very opinionated assessment of the statements provided within the plaintiff's reply brief in opposition to the defendant's motion to dismiss for failure to state a claim upon which relief can be granted. Counsel for the defendants are actually attempting to state that I, as plaintiff pro se, have conceded on various points within the plaintiff's lawsuit based on the plaintiff's reply brief in opposition to the defendant's motion to dismiss for failure to state a claim upon which relief can be granted as statements of fact when there is absolutely nothing of fact based on the defendants via counsel for the defendants personal and very opinionated assessment. For the record, the plaintiff does not concede to anything stated by the defendants. If and when time is or has been taken by the assigned judge, J.P. Stadtmueller, to carefully read the plaintiff's entire brief in opposition to the defendant's motion to dismiss for failure to state a claim upon which relief can be granted, you will see that I, as the plaintiff pro se, have not conceded to anything and have successfully refuted and opposed all statements within the defendant's motion to dismiss for failure to state a claim upon which relief can be granted and has proven that punitive damages can be awarded in any civil suit if the plaintiff can prove with substantial evidence of the defendant's intentional, malicious, and egregious misconduct, and the plaintiff has also proven breach of contract by way of the substantial amount of submitted digital evidence which will corroborate the plaintiff's claims and prove the defendants breached their contract against the plaintiff by way of their actions to intentionally harm the plaintiff's ability to earn ad revenue using the defendant's platform, which has been well documented with a substantial amount of digital evidence provided by the plaintiff against the defendants. Now that the defendants filed motion to dismiss for failure to state a claim upon which relief can be granted sits before Judge J.P. Stadtmueller, I, as the plaintiff pro se, am awaiting an answer which will ultimately alter the course and direction of the plaintiff's lawsuit. If the defendant's motion is denied, an answer must still be filed in lieu of the defendant's failed motion, and the plaintiff is awarded a jury trial. If the defendant's meritless motion to dismiss is granted, I, as the plaintiff pro se in this legal matter, will immediately exercise my right to an appeal as of right, in which I have currently prepared the notice of appeal to be filed with the clerk of court, along with payment of the required filing fee and the docketing statement, which will be mailed within the 7-day allotted time period required to successfully appeal to the United States Court of Appeals for the 7th Circuit. Thank you. This is the official notice of appeal form for the United States District Court, Eastern District of Wisconsin. I have prepared a mock completed form which contains general information regarding the plaintiff, defendants, case number, and the potential date a final judgment could be entered. This is the official docketing statement form for the United States Court of Appeals for the 7th Circuit. I have also prepared a mock completed form which contains general information regarding the plaintiff, defendants, and the assigned judge. I also correctly cited United States Code 28-1332 for original jurisdiction for the United States District Court, Eastern District of Wisconsin, and correctly cited United States Code 28-1295 for a proper jurisdiction of my potential appeal to the United States Court of Appeals for the 7th Circuit. Here is a copy of Counsel for the Defendant's original bloated, cluttered motion to dismiss for failure to state a claim upon which relief can be granted. Why would counsel for the defendants feel the need to submit an additional 7-page reply in support of their motion to dismiss, despite the original motion, which looks like a mini novel, and then proceed to make false claims of concession allegedly stated by me, the plaintiff pro se? I believe it is due to counsel for the defendants not having confidence in their original bloated and overblown motion to dismiss, which I also believe was intended to perplex and overwhelm me, but the defendants most likely were not prepared for my reply brief in opposition to solely focus on the title of their motion and present successful opposition in defeating their motion. I, on the other hand, have full confidence in my reply brief and memorandums part A and B, which is why I simply directed the assigned judge's attention to my opposition reply brief, because there is nothing more to say due to the fact that what has already been stated has defeated the defendant's motion to dismiss for failure to state a claim upon which relief can be granted. Here is proof that I immediately filed my reply brief in continued opposition and mailed a file-stamped copy to counsel for the defendants via the U.S. Postal Service certified mail, signature required, on the same day I received a copy of document 29 from counsel for the defendants via FedEx.